You're probably starting to hear discussions on digital twins or virtual likenesses of people that can move, can speak, can act like a human, created by artificial intelligence. But are you aware of how this could have potential implications on the publishing industry? Specifically, I am predicting in the not too distant future, once this technology becomes a little bit more available widely, we are going to start to see publishers asking for some of the rights and usages of the digital likenesses of the authors that they're working with for marketing, for audiobooks, and more. We are going to be breaking down what we can potentially be expecting and things we need to be watching out for when it comes to adding these into our contracts, because this is not something you should give away for free and should be very limited in what you are doing with your contracts with your publishers. Let's talk to everybody's favorite IP and entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
Right now, there's a lot of conversation, Tony, out in the world about digital twins, using our digital likeness to sign away to create an AI version of ourselves for different marketing events. One of the things I want to talk about is how this could impact the publishing industry. Specifically, do we foresee, and what happens if we do, authors being able to sign away their digital likeness to their publishers for marketing, for audiobooks, and for other ways of getting their book out to the public? What does that look like from a legal perspective?
So I think that, and that's a very real thought that we should all be having for sure, especially with the way media evolve. That's been a consequence since the dawn of time. I think that that's a genuine fact, statement of fact. Now, that said, I think that the landscape right now with the AMPTP SAG-AFTRA strike and their dispute over this very controversial AI proposal may kind of be a little bit of the catalyst that will lead and kind of disperse into a ripple effect as to how other companies are going to approach AI use of someone else's name, image, and likeness for commercial use. So I genuinely think that whatever we get from as an outcome from this strike may be a catalyst that will lead to approach in other aspects of industry. Now, specifically with the publishing industry, that's going to be very interesting. As it is, when usually when an author signs a publishing agreement, they give certain consents to what the publisher can or cannot do with that person's likeness. Obviously, there are certain marketing clauses that where the author is obligated to help market the book, especially if it's a series, market the series of the book. They would have to appear in a certain number of press junkets or have certain obligations of that sort, especially if it's one of the big four that you're working with and you're a bigger name author. Those types of considerations may come into play. Now, I'm going to say that what you're bringing up is almost akin to something that you would also typically see even in, let's say, an influencer style agreement, where you have to wonder in what degree does a publisher have access to your name, image, and likeness. You have seen sometimes brands sort of be a bit cutthroat, and they'll say, we will own this influencer's name, image, and likeness for in perpetuity. So it has these kind of intimidating words, in perpetuity, across all media, across all platforms throughout the world, these catch-all broad phrases, and a lot of people don't realize what they're signing. So if you're an author working with a publisher that wants to use generative AI in some capacity, invoking the use of your name, image, and likeness to help promote the book, that's where you have to be very careful with the read of the contract. You want to make sure that their use of your name, image, and likeness by way of generative AI will only be in connection with this book, will only be in connection with a specific book series, within a limited term, within a limited marketing campaign term. The reason why you want something like that is because you still need full autonomy over your own rights. At the end of the day, you are the author of your own name, image, and likeness. These are your God-given rights. I know that there are people that don't really give love to personality rights because I often regard it as an aspect of intellectual property. People regard it more as a privacy right, which it is. But think of it that way. It's a privacy right that is personal to you. When you are in public and someone takes a photo of you, there is no expectation of privacy. So someone can take that photo of you and they can publish it everywhere. But if you're in a private setting, you own those rights. And if someone is using your likeness for commercial use, that's where it becomes a bit problematic. So all that to say, at the end of the day, when you're working on any type of publishing agreement, you want to make sure that your agreement really spells out at a in very clear language that your name, image, and likeness would only be used in a very specific manner. And obviously, if you have no idea how to read a publishing agreement or you're unsure of how the read of the contract is, hire a publishing lawyer. These people know their stuff. And especially with the way new media is evolving and the way we have this mass proliferation of artificial intelligence, you really, really, really do not want to play footsie with something like this. So having a good publishing lawyer who has that good expertise and knows what rights you have and wants to protect your rights is going to be very essential to this conversation, to this whole agreement working out in favor of everybody. So at the end of the day, make sure that you work with a publishing lawyer who can help you in some capacity get those, get your rights protected and they aren't used and abused in some capacity in the future.
And Tony's being nice about it, saying, if you don't understand it, get a lawyer. What I'm telling you is you do not sign anything ever without a lawyer unless you are a lawyer. So make sure you have a publishing lawyer. And in a conversation related to something kind of as futuristic as artificial intelligence, something that is brand new, you need one that understands that too. Don't just get anybody who has been around the block for a long time but has not studied up, because that's not going to serve you well. You have to make sure somebody knows what they're talking about before they give you guidance on it. With that in mind, Tony, we are going to start, I predict, seeing some of these clauses inside of contracts. We're going to start to see things, even though we don't necessarily have access to the technology yet. I very strongly predict we're going to start to see these clauses being slipped into our contracts. We've had discussions before about dealing with author and publishing contracts. We've talked all about negotiating them, that we do, in fact, have the power to negotiate them. But let's say somebody already has contracts signed, and now these publishers want to come in and add in clauses to change things. Do we need an entirely new contract? What do we need to know about people and publishers who may want to add in things to past contracts?
So again, with addendums, which are very common in not even just in the publishing industry, but in any business where contracting happens, this is where you're going to need to have a lawyer in place to help you, because yes, there could be an addendum offered to you in writing, but I think what could benefit first is having an oral negotiation between you yourself, the author, with your legal representation and the publishing house. That way you can both have at least some type of mutual understanding before any sort of paper gets exchanged as to what the expectation of this addendum is going to be. Party A can say what their expectations are. Party B can share their expectations. They bicker, they go back and forth. You get to the resolution. You get to what will ultimately be agreed upon. That's the essence of the meeting of the minds, this policy argument that is so core to contracting. Again, regardless of industry, publishing, media, even real estate, the meeting of the minds is a core part of having a good and valid contract. So I think that that's going to be a very essential part of this process. Are addendums commonplace in the publishing industry? Of course, it happens all the time. Think of even when second edition or third edition of books happen. Yeah. The first contract still governs in some capacity. It's just you're adding a little bit more to the second edition or this third edition. There may be new considerations that weren't contemplated in the first contract that maybe need to be contemplated in the second, third, fourth, fifth, whatever edition of the contract or the book that you're working on. So I think that that's something that surely it should happen. An addendum should happen. You should not work off of blind assent or a gentleman's handshake, just not going to fly in a court of law whatsoever. You're better off having all that memorialized in writing. And especially with this mass migration of AI in every aspect of industry, you need to have those terms especially laid out and explicitly written to in some type of additional contract that still allows the original contract to govern, but still will operate as a very strong and solid binding aspect of law.
And because I know I'm going to get this in the comments, yes, you can say no if it's an addendum you do not want.
That's exactly right.
You don't have to have it. If you've already signed that contract, you do not have to change it if you do not want to. And if you are getting a new contract, all those things, like we mentioned before, are negotiable, which is why you need a good lawyer, because these people can guide you through the process of what's going to work for you and serve you and what is not, and have that conversation about making sure it's working for both parties. As always, if you have questions about publishing and the legal side of things, go ahead and drop those down below. We're going to continue our discussion on how AI is impacting the publishing industry. We've got a full playlist on the legal side and on the ethical and creative sides of how you can be using it inside of publishing. But we will be bringing you breaking news as more court cases roll out and more technology becomes available to us. As always with this, you want to be very careful with your contract that you have everything very spelled out. And if you're uncertain, ask people. Tony is a great person to be asking questions on what you should be asking your lawyer. So if you've got questions on that, you can always follow him on his social media and reach out. Where can everybody find you, Tony?
You can find me at the IP Professor on Instagram, YouTube, and TikTok. And you can check out my entertainment law podcast, End Scene, where new episodes drop every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Hit the subscribe and notification bell because we are continuing our discussion on artificial intelligence and the publishing industry. We do have a legal playlist on AI and the legal side of things. We also have a playlist all about AI and publishing, how you can creatively and ethically be using an artificial intelligence to thrive inside of your publishing business. Drop your questions down below, and every single day we drop new videos to help you navigate the world of writing, publishing, marketing, and making sure that this is your most profitable author year ever. We'll see you in the upcoming episodes.